Welcome to Ground Rules, Employment Law Over Your Coffee Break. My name's Pam Howland, and I'm here today with Jennifer Walrath. Doug Plass, who's usually with us, is still vacationing. He's taking some well-earned time off, but I think we'll see him again here maybe next week. So today, Jennifer and I thought we would take advantage of the opportunity to talk to you about what it's like to be in court, what it's like to be in trial. And for those of you who don't know this, that's part of why we decided to do our podcast, why we decided to write our Law for Leaders book, and why we have our training platform is because we are litigators. We do go to court. We defend employers when they have claims and lawsuits brought against them. And as a result of that, we have a pretty good pulse on what it's like to actually be involved in litigation or a lawsuit, and even to be in trial. So we know that not a lot of cases go to trial. I think the percentage is under 2%. But a lot of cases are in court where you're going to court, making arguments, trying to win on different legal issues. And Jennifer and I recently had the opportunity to be part of a trial involving a case that involves some employment law and business issues for a client of ours. And we thought that it would make sense to take some time and unpack what that was like and share with you some of our takeaways of what it's really like to be in court, what it's really like to be in trial, and to really emphasize to you just how important it is that you need to do whatever you can proactively to avoid being in court and in trial. So Jennifer and I both have developed our own lists on what types of things we think are important, what type of takeaways we have from the trial we just recently participated in, and we haven't shared with each other what's on each other's list. So I'm kind of curious to hear what Jennifer's got on her list. So I'm going to kick it over to Jennifer and let her start off with some of her takeaways on what it's like to be in court.
Well, I won't give you the rundown, so I think I'll start with the one that, uh, I think every time I've been in trial consistently is something that, is a takeaway for me, and that is that so much about being in trial is unpredictable and outside of your control. You have control over your decisions, what you present as evidence, you know maybe what witnesses you put on, right? So there are certain things that are within your control, but you have absolutely no control over how what you present is perceived by the jury. It's a jury trial, which is what we're talking about here, or potentially even a bench trial, how the judge sees what you present, right? When you have a jury trial, the judge might make certain decisions or rulings on issues of evidence, right? Like what actually gets to be considered, that you don't know what's going to happen until it does. And sometimes those rulings really impact your strategy and what you are planning on doing. Um, and all to say, like on any given day, you can walk in with a plan, and within an hour, everything has changed. That's even just day to day. And at the end of the case, what the jury, when you sit there and listen to the verdict, sometimes you're scratching your head wondering what happened. Uh, and that is just kind of the nature of the beast. But I think it's just difficult to navigate for the attorneys and their clients. Um, and there's not really any way around that, I don't think. And so just to kind of keep that in mind, that no matter, you can do the best possible job, clients can do a great job on the stand, and you still might come away with something that isn't quite what you wanted.
Yeah. If you are the type of person who likes to be well prepared, prepared in advance, to know exactly what's going to happen and exactly when it's going to happen and how it's happened, then you will find trial particularly uncomfortable, because on any given day when you go to trial, You have a general idea of what might happen, which witnesses might be called, the time you'll be there. But in our recent 7-day jury trial, I was blown away at how many days we thought the timing was going to go one way, and it ended up going a totally different way. Maybe a witness was on the stand longer. We had some witnesses prepared to testify, and as we went to call them, the other side said, no, we object, and we're moving to exclude them. Suddenly, a witness is completely off the list. So when it comes to unpredictability, absolutely, trial, there are not a lot of things you can control about that. And I'm going to piggyback. I also had on my list the jury is unpredictable, like Jennifer said. You spend a lot of time in trial trying to guess at what the jury is thinking. And that is really stressful. You might think, okay, it felt today like we had really good energy and things were going one way and the jury seemed to be on our side. And then you might have the next day where you're like, things felt off today. Like, I wonder if the jury's upset. I wonder why they're mad at us. I mean, there's so many jury wild cards. That makes it really stressful. It's stressful for us, but if you're the employer paying for it, who has a whole lot writing on it, maybe a potential judgment that might get entered against them, a large amount of attorney's fees that they might be assessed, that becomes particularly stressful too. So absolutely, jury unpredictability, schedule uncertainty, all of those things are definitely the hallmarks of a trial. Go ahead. What else do you have on your list?
Well, and I think Pam already mentioned this, but one of the other things that's just sort of reality, but it's, uh, I'm sure disheartening for clients, for employers, right? Is that no matter how you slice it, going to trial is time consuming and expensive, right? You have your attorney time. You might be paying expert witnesses to come and testify for you. Um, if you are the representative of the employer who's sitting in court day in and day out, that means you're not doing your regular job, right? So, maybe you're not out there, making sales to make money, or maybe you aren't at your desk doing your job. So, some operational things are falling through the cracks, right? So, there could be some actual just business impact on having to devote people to be involved in the trial on behalf of the employer. Maybe the employer has other employees who are coming to testify as witnesses. So that can just be a very big drain on the time and productivity of the employer. And then on top of that, having actual dollars out the door to pay for, all the services being provided to actually make this trial happen.
Yeah. That's on my list too. Expensive, exclamation mark, exclamation mark. Not only is the trial itself expensive, but just getting there is hugely expensive. I think that is something that's surprising to a lot of employers who have never been in a lawsuit. Sometimes we'll have employers who hire us to defend against claims and they'll say, okay, just, push this to a resolution, get it in front of the court, get a decision from the court. It just doesn't really work that way. I mean, our whole system is set up so that both sides get due process. That means both sides get a whole lot of time to get evidence from the other side, to talk to witnesses, to depose people. And at the very beginning of a case, there's going to be a scheduling order entered that sets timelines for all of that. And it's typical for most employment law cases to get an initial scheduling order that's going to have dates pushing these different deadlines out at least a year. So it would be hugely unusual, I would say, to get some type of court decision before you get through those deadlines and before a year runs, really. Once in a while, if there's something extraordinary going on, like maybe the employee waited too long to bring their claim, so the claim's time barred, maybe you could get a decision that way that before a year. But generally speaking, it's going to take at least a year to get it through the system before you can tee up big issues with the court. And I would say that's a best case scenario.
Yeah, and that brings me to another one of my takeaways too is that after you go to trial, even if you win, like let's say you win a verdict, you get some money, you might still feel like you lost because it did take so much time and, resources to get to that point. So, in some ways it's like the cost benefit analysis definitely if you can at all avoid it and figure out a way as early as possible. Sometimes it's not possible to do it right after a case starts, right? To get it resolved sooner is always going to be better. And of course, as we always are talking about, to even avoid getting there in the first place is sort of the best, right? So just to keep that in mind, right? I mean, even if you win, you still might feel like you didn't really win.
Yeah. And that when you start doing an analysis on it of how much do we need to win in order to make this worth our while, obviously, the more time that goes on, the higher the attorney's fees are. You start looking at it going, wow, writing a settlement check, maybe it would have made sense. I mean, again, there's a lot of reasons that employers fight things, and we're always going to be there advocating for our clients. Certainly don't take us wrong there, but the time element is a huge problem. And in our last case that went to trial, for example, 4 years really from the time that lawsuit was filed until it ended up in trial. Why? A lot of different reasons. There were a lot of legal issues that took a long time to work out, and it is not uncommon for a scheduling order to get issued and then for it to get amended and for the trial to get pushed out. So, a lot of things can cause the case to take longer than a year. And I will say in Idaho, my experience is the judges are busy. So, it's not like you can just say, hey, we want to get ours heard quickly. Please schedule it for trial as soon as possible. It just doesn't work that way. The judge does what the judge can with their schedule. And a lot of times that is not favorable for the employer defending against a lawsuit. So, a lot of wild cards with how long it takes and how expensive it is. The other element of expense is, if you're really going to do it right, there's so much prep that goes into a multi day trial. You get one shot in front of the jury, and depending on the number of claims you have, the number of witnesses, the prep time even leading up to the trial, and then imagine, you're pretty much working around the clock from the time the trial starts until it ends. That ends up in a pretty hefty price tag, no matter how you cut it. So that's tough for clients too.
Yeah, I've told some people have been asking me, what's it like? And I said, it's all consuming pretty much, right? If you are um, doing it right, and especially a case that is a little more complex, which a lot of employment law cases can be that way. It is very busy leading up to trial for sure.
Yeah.
And then, one other thing I had on my list, which again is not limited to just our last trial, it's been the case in past trials I've done as well. Even once you've gotten the verdict, it's still not done, right? So you've spent years litigating this case, you've spent, weeks, maybe even months, days for sure, getting ready to trial, being in trial. And then, there could still be issues that a judge has to decide, issues of fees and costs. Maybe one party decides to appeal, right? So there are still all kinds of processes and things that uh, are likely to or may happen even after you're actually done with the trial itself, which still more time, more resources. And I think it's just easy to not think about those, the sort of the post trial issues. Sometimes there's also post-trial motions that get filed, for various reasons. So, the trial itself is the trial, but then you're probably still not done, and there's more that actually could be happening after that.
Yeah. And that's another big consideration, when you're thinking about bringing a lawsuit, maybe proactively bringing one. Sometimes we see that in our, for example, confidentiality breach or trade secret theft, cases like that, analyzing will there be any money to collect at the end of the day? You don't like, again, all of this, so much time, so much money, it's gotta be worth your while, and you can't do it based on emotion. It's gotta be based on dollars, and if you go to all this trouble, what is the end result gonna be, and will it, even if you win, if everything goes perfectly, is it gonna be worth your while? Another very, very important question to think about.
Yeah, I mean, we have counseling conversations with clients, I would say fairly regularly, when we get questions like, what's the risk look like? And, that's going to vary claim by claim. But one of the risk points frequently is look, even if the employee doesn't have the best claim against you, you still have to spend time, money, defending the claim. And as we've been talking about here today, you don't know for how long in every case that's going to go on, but it certainly factors into is it worth it to make a decision that may end up leading to an employee filing a claim?
Yeah. So I also have on my list exhausting, stressful, nerve-wracking. So, we've talked about a lack of predictability. That's one type of stress. But for employment law cases, and we talk about this from time to time, if you are the decision maker, the owner, the leader whose decision is being challenged, cross examination, really being the key company representative who has to carry the day for the employer can be hugely stressful and exhausting. And the way that a lot of attorneys try to shoot down the credibility of a witness is by trying to make the witness look like they're dishonest, lacking in integrity, maybe just not a credible person. And if you're on the receiving end of questions aimed at making you look that way, it's a very unpleasant place to be. So, I sometimes we tell clients, like, hey, you probably want to do whatever you can to stay out of court. And once in a while, we'll have someone who kind of has the attitude of, well, I always wanted to go to law school, and I think I could do pretty well. I think I could go toe to toe with any plaintiff's attorney. And I would just say that when you're knee deep in that, watching someone get cross examined effectively, even your deposition, before you end up in trial, those are not particularly enjoyable experiences for the company representatives. We do it enough. We know what's going to happen. But I think if it's your one time having that experience, it's kind of shocking and stressful how that goes. So, Jennifer, you got anything else on your list, or did we kind of cover them?
I think we got most of them. I'm curious to see what else you've got.
I did have like a couple of bullet points related to jury uncertainty. Like we talked about a lack of predictability, but I think one of my big takeaways whenever we have a jury trial is it's just fascinating human nature and jury dynamic and what you might think after being in a case or a lawsuit for years is such an important thing and such a key thing might not really be that important to a jury. And that there are always going to be outside forces and maybe outside experiences impacting a jury that you really have no way to know in advance. And even the most skilled litigator who tries to ferret that stuff out in the jury selection process may not be able to find that stuff. So there really is just a level of uncertainty that goes with any jury trial, that even when you have a case with great evidence, great witnesses, there's a level of uncertainty there that I think is fascinating and horrifying all at the same time.
I always tell the story, like, years ago, I did one of the, like, trial training classes and did a mock trial, and then they, let you watch almost like a candid camera, the, jury deliberations, and I really cannot tell you how many times the various attorneys, who had done this mock trial, smack their head and go, "Oh my goodness, where did that come from?" And on both sides of the V, right? Because you pick a side, one side's plaintiff, one side's defendant, you represent your side, and then they go and deliberate. And, it wasn't just, one mock trial out of 10, like pretty consistently across all the mock trials, everyone who participated as counsel had a similar story to tell, where there was something the jury talked about that kind of came out of left field in terms of how they were thinking about their case. And it surprised them. And I think that's just Eg an example, right? I mean, obviously, we don't get to watch juries deliberate in real life, but I think it does happen more often than you might think it does, that a jury just starts to think in a way that maybe you didn't anticipate and couldn't have
Yeah.
anticipated.
Yep. I mean, we work with jury consultants from time to time. I mean, there is a real concept of anti corporate bias, a very real concept of anti government bias, and if you're an employer, those things could impact you. It really is fascinating. And we've had a handful of examples where maybe a jury comes down on the side of kind of what we would call splitting the baby, like rather than really like picking what in our view would be the right decision, maybe kind of saying, okay, well, we're going to kind of like, we think everyone was kind of right and everyone was kind of wrong, and coming up with a middle of the road decision. So, all that to say, a lot of wild cards, a lot of uncertainty. We have statistics. We've talked about them in our podcast, but I think maybe it's worth like reminding everyone what those statistics are. In Idaho right now, we know that the average jury verdict in Idaho over the last 5 years, and I don't think the statistic counts 2025. So it kind of would be interesting to find 2025 cases, but the 5 years prior to that, there has been some analysis, and the average jury verdict in the 5 years prior to that's right around $1 million. So, not great for employers. And the average time it takes from the time a lawsuit's filed till the time of trials, right around 2.5 years. So those are very interesting statistics. Average settlement amount right around $130,000. So all of that points to give it careful thought if you're involved in litigation. Once you have that lawsuit brought, carefully think through what that process is going to look like. Maybe even more importantly, what should you do to stay out of court entirely? Because there's a handful of those things too. And it certainly makes sense. And maybe as we wind up 2025 and head into 2026, those should be things on your to-do list to try to make sure you've done everything you can as an HR professional, leader, business owner, to make sure you've done what you need to do to stay out of court. We were on a panel in September where we had an Idaho Supreme Court justice on that panel, and she was talking about the importance in employment law cases of having good documentation, supporting that you did what you did for legitimate, non-discriminatory reasons. So, really, that's coming from a judge. That's not coming from us. She said, if your case is appealed to me, and you're arguing that you should prevail, that's what I'm going to want to see is your documentation. So right there, do you have good documentation? Do your supervisors know how to document? Are you doing what you need to do when you're disciplining and terminating? That is one thing you could do. Jennifer, do you have other things on your bullet list that employers should be doing as they wind this year up to stay out of court?
Yeah, I mean, I guess it's sort of documentation, but policies. We talk about it a lot, but make sure you have a handbook with policies, that they're the right policies, they're updated policies. And then I think I'm becoming, job descriptions, right? It, have them.
Yeah.
It's very helpful for a lot of reasons, including for performance management. Um, if you haven't looked at any of those things in a while, now's a great time to go kind of dust off what you have, take a look at it. And if some updates are necessary, take the time to do that now.
Yeah. Another thing would be watching the law. Is this year's been crazy, and even today we were talking. I think we are going to continue to see as 2025 wraps up some movement in big employment law issues with the EEOC and otherwise. Things are changing quite radically, I would say, and it makes a lot of sense to watch that, to be aware of that, and to know what that means in your workplace for your policies and protocols for sure. I would say another thing you could do if you're looking for a great Christmas gift, our Law for Leaders book is the perfect stocking stuffer, right? For all the HR business leader, maybe you got kids coming out of college who need to know what to do in the workplace. That is a great gift. And it's a good thing to have on your desk, really. Like before you make a decision on the ADA, do you know enough? Do you need to open the chapters on the ADA, for example, and make sure you know enough to comply with the law? So, another suggestion, just getting your training house in order. Are your supervisors up to speed on the key developments in the law? If you're listening to this, chances are you are, but are the supervisors, can they spot issues to give them to you? So that's it for today. That's a little peek behind the curtain at what it's like to be in trial. We hope you join us next time for Ground Rules, and we'll see you soon. Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.